What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? A third time today for some of you being here on stream, talking about this Idaho case. So much is happening, and it's got so much attention that I think people are interested in trying to understand the process, why decisions are being made, why Bryan Kohberger is doing certain things, why his attorneys are doing certain things. So we're going to break that down today. And we're going to be able to dig a lot deeper because I did want to watch this hearing just us, as I say, the crew here on The Lawyer You Know. We can get with this chat specifically. It's fun, going on other channels. I've got a couple other channels I'm going on. I think I'm going on one tomorrow. I'm going on one Tuesday. So we'll be posting on social media for that at Tragos Law here on Instagram and Twitter. If you haven't followed us on there, now would be the time to follow us because we're going on a bunch of different channels and we're talking about this stuff. People have questions. Yes, just us. How romantic. Exactly. So make sure you subscribe and become a part of this community because we have a lot of fun here. We talk through a lot of things here. Kind of have a different setup at my house. We're working on it. It's a work in progress. I tried to set it up tonight myself without John. That's why the lighting's not great. The camera might not be great, but we have the camera actually plugged in and set up. It's kind of high, so I'm looking up when I'm looking down, and we're watching this together. So it's going to be fun tonight. It's going to be kind of chill. We're going to dig a little deeper, a little more explanations than sound bites that you may have heard elsewhere, because I know you guys like to dig into the law, why it's happening, what could be next. We're going to answer all sorts of questions. We're going to watch this hearing together. We're going to talk about what rights he actually waived. We'll talk about why they waived those rights, what's next to come, what happens at a preliminary hearing, what we expect to happen at this preliminary hearing. We'll talk about all that and more. And of course, I will answer a ton of your questions, as many as I possibly can. But hit that like button if you haven't already. We already have about 2,000 people here. So let's get to 2,000 likes. Let's keep the likes in line with how many people are watching. So hit that like button before we start and subscribe if you haven't already. Speaking of subscribers, we hit 175,000. So that means two things are going into effect here, okay? Thing number one, I told you we're going to do something we've never done before. A lot of you members in here, some very specifically, have led the way and led by example for the whole community with gifting memberships. So we, this weekend, are going to be gifting a bunch of memberships. So you're going to want to subscribe and hit that reminder bell because when we go live, we're going to be gifting memberships. And I saw some people asking that are about when the next members only video is going to be. And it's going to be next week. And in case you haven't been in any members videos, they're fun. They're laid back. They are not diving and digging into a bunch of legalese and defining a bunch of things. We answer a lot of questions. We talk about life. We talk about different things. This one's going to be focused on the YouTube channel, what I'm doing, how I'm doing it, what equipment I'm using, things like that. A lot of behind the scenes. I'll save a lot of it for that members only video. But I'm going to be giving away a bunch of memberships this weekend before the next video. Don't feel like you have to join the membership. It's just something extra, something fun. The legal breakdowns will always be here. But I don't like to do this like huge intro. So I plan on saving that for later, but I just jumped into it because we were talking about subscribing. But here's what we're going to do. We are going to watch this hearing together first. Then we're going to talk through all of the different things that come out of this hearing. And of course, I'm going to get to all of your questions. So without further ado, let's share the screen here and make it happen. Have it turned up all the way. Audio is not always the best in these hearings. Thank you for everybody congratulating us on 175K. Thank you, Cheryl.
Right, good morning. We are on the record. This is cause number CR 29222805. This is State of Idaho versus Bryan Kohberger. Mr. Kohberger is in custody. He is appearing here in court with his attorneys, Ms. Taylor, Mr. Logston, Mr. Thompson.
All of this is for the record, as you guys know, but that's why the judge reads this at the beginning of these hearings. I hear the rumblings coming through, so if the storm knocks me out, then I'll be back with you guys when I can.
Ms. Jennings appearing on behalf of the state. This is the time set in the matter for the preliminary hearing status conference. So I am going to.
So this was set, and just so you know, this was set. Oh, and we are going to get to the scratches on his face here real quick, but this is set as the preliminary hearing status conference. Okay. Now, one of the reasons for doing that is in case there was an issue with his rights and the timing of the preliminary hearing, which has to be done within 14 days of his arrest in Idaho. That's his right, unless he waives it. The judge set this very smartly as the preliminary hearing / status conference. So if they're ready to go with the preliminary hearing, let's do it now. We're well within his rights. But as we hear, the defense requests a continuance, kind of a pushing out of this preliminary hearing. You put that onus on the defense so they can't claim any foul play or any violation of any rights in the future for this preliminary hearing. To take a second to talk about these cuts on his face. Apparently, it's been confirmed that this was from shaving. I guess everybody was talking about it. The razors aren't great. We talked about how the vegan food, they may give you vegan food, but it's not the Ritz-Carlton. It's not the best vegan food. It's not your own plates and pans and pots. And they may give you razors, but they don't give you the best razors. And I guess it's been reported from somebody at the jail, even though there's a gag order, that this was just part of shaving, how he cut himself. This wasn't from an incident. He obviously wants to be clean shaven. It looks like he's got some product of some sort in his hair. People are like, of course, you'd notice that. But it seems like he wants to be presentable when he does come into court. Now, what that goes into, I don't know. We can talk about that if you guys have feelings about it, but I did want to mention it because I know the chat's going to be blowing up about questions about the scratches on his face.
Choir of counsel, Ms. Taylor, what's the status at this time?
Thank you, Your Honor. We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing.
So a couple things. The defense is requesting that this gets pushed out until June. It is their prerogative, and they can do that because it is his right. It is Bryan's right to this preliminary hearing, which means he gets to hear all the evidence against him or a lot of the evidence against him within 14 days. Welcome to all the new members, to the jury, to the gallery. And then the second thing that's very important is they think this is going to take 4 to 5 days. That is a really long preliminary hearing. Some preliminary hearings take 30 minutes. Most of them can be done within 1 day. So to have a 4 to 5 day, and you'll hear later that the judge ends up reserving 5 days for this preliminary hearing, means there is going to be a lot of evidence presented, a lot of cross-examination, and this is not going to be in and out. There's going to be a lot here, and we'll talk about exactly how a preliminary hearing works later in the video.
Mr. Kohberger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
And Mr. Thompson, are you in agreement with that?
The state has no objection to that, Your Honor. Ms. Taylor reached out to us by email yesterday with her proposal. On reflection, the state's calendar would be better in the month of July, but we will make the end of June work if that's the court's preference. And I haven't had a chance to talk to Ms. Taylor about that. I'm sorry, I know that's last minute.
That's okay. The court's calendar is going to be better towards the end of June, early July. So would that work, Ms. Taylor, for your scheduling on your other matters?
Your Honor, yes. If we take that 4th week in June, that's actually best.
Okay. So, Mr. Kohberger, I need to speak to you for a moment then.
We call this a colloquy. The judge talks to the defendant. We get the defendant's own words that he understands and waives these rights. We don't just take the word of the lawyer. This is how it's supposed to be done. This happened in Darrell Brooks's case. This has happened in a lot of cases. So regardless of what criminal defendants may say later, the judge asks them questions like this. It's similar to when they decide not to testify and things like that. But anytime they waive a right, you want to get it on the record that they are doing it of their own free will and nobody is coercing them or tricking them into doing this. A ton of new members tonight, which is awesome.
Sir, you do understand, and Ms. Taylor has represented here, that she's advised you of your right to have, or fully discussed with you the right that you have, which is to have your preliminary hearing within 14 days of the date that you initially appeared before this court. As you recall, when I advised you of your rights, that hearing is a probable cause hearing where the state has to establish that more likely than not, these felony offenses were committed and you were the one that committed the felony offenses.
So that's the burden. More likely than not, the state has to present evidence. The judge is the fact finder. The burden is that he, Bryan Kohberger, more likely than not, committed these offenses. Not beyond a reasonable doubt, not a jury trial. This is not a preliminary trial. This is a hearing, and a decision is going to be made by a judge.
If you waive your right to a speedy preliminary hearing, it does not mean that you're giving up your right to have a preliminary hearing. It simply means that you would not be able to come back and challenge that the state did not present probable cause within 14 days. Do you understand?
Yes.
Have you had enough time to
So he understands. She laid it all out, explained it all to him, and he very clearly understands. And since we've heard from his prior public defender, he's intelligent, he's calm, he understands what's going on. That's confirmed here in court.
with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
So he is waiving his right to a speedy preliminary hearing. Now, I usually don't hear judges call it a speedy preliminary hearing because that gets confused with speedy trial. I've heard some people from some other media outlets saying he waived his speedy trial. He did not waive his speedy trial, at least not in this hearing, not from what we're listening to. They could have filed a notice of it that I haven't seen yet. But to me, he has not waived his speedy trial at this point, just the preliminary hearing, which he had a right to have within 14 days.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
As clear as can be. This judge is laying it all out on the record. It's very clear. She's doing a great job, and he's answering as quickly and easily and directly as he possibly can with yes or no answers, as he should.
Ms. Taylor, do you concur with his waiver?
I do, Your Honor. Thank you.
I will find your waiver of speedy preliminary hearing is knowing, intelligently, voluntarily entered here in open court with the assistance of counsel. We will go ahead and set the matter for
Knowing and voluntary, those are the magic words.
preliminary hearing.
She's setting the preliminary hearing for the end of June, basically. I think it's June 26th or something.
Monday, June 26th at 9:00 a.m. And I will go ahead and reserve the week, so June 26th to June 30th.
So she's reserving 5 full days because that's how long the judge thinks it's going to take based on the defense attorney saying 4 to 5 days. So 5 full days for a preliminary hearing. Brian said, how long was the preliminary hearing in JDVAH? This is a criminal case, so totally different there. They didn't have a preliminary hearing like we have in this case, so you can't really compare it. I think the Courtney Clenny OnlyFans preliminary hearing was less than a day, I want to say. And then I think the Valo Daybell one may have been longer than a day, but it was not 5 days. I've got to go back and look. I don't know that off the top of my head, but all the ones I've been in have the vast majority have been within 1 day.
In the event that we need all 5 days for presentation of evidence.
This is awesome, Sarah. So lots of memberships are going to be gifted through this weekend.
And just so council knows, it will begin at 9 a.m. each of those days. Is there anything further to address at this time in the case, Mr. Thompson?
Not from the state's perspective, Your Honor. No.
All right. or Ms. Taylor?
No, Your Honor.
Okay. Mr. Kohberger, then you will be remanded into custody on your same no bail at this point in time, pending further proceedings. Again, we'll send notice out to council, and we will be in recess for this morning.
Thank you, Your Honor.
Thank you.
And that's it. I mean, that's really it. I'm going to leave it up there just for a minute in case you guys have any questions and we need to pop back and listen to any more of it. Thank you, Weldon. But that's basically it. So first thing I'm going to do is answer some of your questions, and then I'm going to break down some of the stuff that I do want to get to about preliminary hearings and about the timeline of this case. Allie Foley, can they file a motion for change of venue between now and June? Why will the hearing be over multiple days? I wouldn't expect them to file for change of venue between now and June, but the hearing is going to take multiple days because of all the evidence that needs to be presented and the cross-examination that the defense is going to do. It's not just like you think about the probable cause affidavit. There's going to be way more evidence presented in a way more scientific and professional way than we read in the probable cause affidavit, which is basically one officer relaying what he read, what he saw, what he heard, who he spoke to, and how he put all the evidence together. This, we're actually going to have people testify. Law enforcement officers will testify. We could have live witnesses testify. We could have experts testify, and then the defense gets to cross-examine them. So, that's why it's going to take multiple days. Amy S. Question, can they change venue to a neighboring state if they can't get a fair trial? And how does that happen? Yes, it is possible. It's unlikely. It's reserved for very, very certain circumstances and extenuating circumstances. But if it is impossible to get a fair jury anywhere in the state of Idaho, then they could potentially go to a different state. More likely, they'll go to a bigger or more populous county, or pull potential jurors from other counties to come to this county. And the way this happens is they have to file a motion. There has to be specific findings of fact, and you apply them to the law that you can't. And based on these facts and the law, you can't get a fair trial. And in order to get a fair trial, 1, 2, 3 options that we could do are a different state, a different county, or pulling more jurors in. And then the judge makes the decision as to what's the best way to get a fair trial in this case. Lita, I was part of the rewatch crew from earlier today, including you with JB. Congrats on 175K. Great work, Peter. Thank you so much, Lita. Mary Farrell, do you talk with Black Belt Barrister? I don't. We were supposed to do a live together. We went back and forth trying to schedule stuff during, the Amber Heard Johnny Depp appeals, but I haven't really talked to him since then. Jennifer Landers, why so far out? So they can prepare better. I think I can pull that off the screen for now. So the main reason that I would see for defense attorneys or a defendant agreeing to push this preliminary hearing out 5 months until June is so that they can try to catch up with what the prosecutors and law enforcement have already done in this investigation and in this case. We know for 6 weeks before they ever made an arrest in this case, they were preparing, they were gathering evidence, they were talking to witness, they were testing evidence. And now all of a sudden it's time for the preliminary hearing, where the defense attorney, here's how a preliminary hearing goes. The prosecutor puts on evidence before the judge. They have to prove that it's more likely than not that Bryan Kohberger committed these crimes. It does not mean beyond a reasonable doubt that he's going to get convicted by a jury, but it's basically like enough for probable cause. They can continue to hold him without bail, and they can continue to go forward on these charges. If they lose that, then he gets to go free. 99+% chance they're going to win that. But the defense gets to cross-examine these witnesses. They also have an opportunity to put on witnesses, but it's unusual, and usually they don't. And there's a reason for that. And there's a reason most defendants don't waive this preliminary hearing, because the main reason in this case I could see for Bryan Kohberger wanting to waive it is he doesn't want the court of public opinion to convict him based on this evidence, because this evidence is just one-sided. Basically, the state's going to put on the vast majority of evidence because the defense usually holds their arguments a little closer to the vest, but the state has to put on enough to get past this more likely than not that he committed these crimes. So the only reason to waive it would be after everybody hears all this evidence, which happened kind of in the Vallow Daybell case. Netflix documentaries used the preliminary hearings and the evidence presented there to convict them basically in the media. So you don't want to have that happen. That's the only reason I could see you waiving it. But the benefit of having this preliminary hearing is so much more important for your strategy and for your defense, because you get a look at the state's evidence, how they're going to present it, who is going to present it. You get to cross-examine them and pick it apart. Then all of that is sworn under oath testimony. And as we saw with the Johnny Depp case, as we've seen with every case where a deposition or a prior statement is used to impeach a witness, the more statements you have under oath, the less likely it is that stories change. And if those stories change, you can impeach those witnesses for changing their stories. So in the time, to answer Jennifer's question, in the time from now until June, the defense gets to catch up on all the evidence. They get to go through it. They get to have their own experts. We already know they have experts. They get to have their own experts look at the evidence, look at the testimony that's going to come from the state, help them prepare questions for the state's experts and the FBI agents that handle the pinging cell phones and how they tracked where the car was and the trace DNA evidence and the testing that they did. They get their own experts to help them formulate cross-examination questions. That's what happens when lawyers have experts. It's not just the testimony that they give from the stand. Sometimes you just have consulting experts, but even testifying experts many times can help lawyers prepare the questions and the way that they're going to pick apart the state's experts in this case. For example, if they get a cell phone expert and they get the report from the FBI will produce a report. Here's how it pinged. Here's where it pinged. Here's how we got it. He even may have gotten onto their Wi-Fi. Then the defense expert can say, this ping, actually, he could have been 40 miles away. So ask that question. Ask, he could have pinged here and been 40 miles away from this house. Isn't that true? And those are the types of things that can happen when your expert helps you prepare to cross-examine the other side's experts. So it's really about catching up, preparing, and doing your due diligence before this preliminary hearing happens, and then using it as basically a free deposition, because some of these people you'll also be able to depose in cases, depending on what the laws are in Idaho. Some states allow different discovery and different depositions that are allowed in different criminal cases, but this will be an additional sworn statement that they will have, and they will know what's happening before the trial comes. So it's very advantageous for the defense to get all this information, to know what the state has against you and how they're going to present it. And if they have a motive, maybe, or if they have a connection between the suspect and the victims. CMS, hey, Peter, with the preliminary trial hearing being pushed off until June, do you think it goes to trial this year? I don't, but under Idaho rules, I believe that after this preliminary hearing, when the information is filed and he is arraigned after the preliminary hearing, that Bryan Kohberger could still demand a speedy trial within 6 months of that. So whether or not that's within this year, I think it's right around the end of the year. I don't really expect that to happen. I would be shocked if this case went to trial this year. Mabel Quintilla. Hi, Peter. Question. What happens if a defendant escapes and is later caught while waiting for the next hearing? Is a new charge added? Yes. And this happened with Ted Bundy. More charges are added. More strict restrictions are put on him in prison. That could even potentially be used during his trial. They can try those two charges together, which makes him look even worse for him escaping prison. So yes, more charges would be added. PK Originals. Will he be allowed to continue his college classes in prison? He won't be allowed to continue his college classes at Washington State. They do have some educational programs and books and things that you can read and degrees that you can get still while you're in prison. So he could potentially still get a PhD in prison, but it won't be just continuing his classes. DC Primetime, congrats, Peter, 175K, to the point and informative. Yes, and I'm still going to try to remember the next milestone, what the goal is going to be and how and what we might do when we get there. Jennifer Gilly, welcome to the gallery. Daniel Ortiz Lopez, you know you've made some questionable decisions in life if you found yourself being prosecuted by Santa Claus. Greetings from Boise. Daniel, you're not supposed to make me laugh at stuff like this, but that was a good one. Willie99, is it possible he can beat this? If so, explain, please. So we've gone through this, right? It's definitely possible he can beat this. I think right now, if we had to guess or we were putting percentages on it or, we were betting men and women, you got to bet on the state. With the national attention, people want justice. They want this to be the right guy. They want to get the right guy. They've got all the CSI evidence, the DNA, the cell phone pinging, cameras following the car around. They've got their story put in place. A motive would be nice. But so right now, heavily leaning towards the state. But there's no, in my opinion, smoking gun yet. There's no eyewitness of him committing the crime. I know there's an eyewitness that he was there, that he was walking down the stairs, potentially that it was him. There could be some credibility issues there. We don't need to get into that again. We've already talked about that ad nauseum. But when we talk about the evidence in this case, there are arguments against every single one. They will have experts that say the cell phone pinging doesn't actually mean he was right by the house. They'll have experts that say the DNA evidence is not as strong as it may seem because it can be transferred, or it could have been, a high five that he gave somebody and that person had the knife. He could have let somebody borrow it. It could have been stolen, whatever it may be. They'll be able to talk through that. IDing that he was actually in the car during the times of the murders at the house. They don't necessarily have that. So they can say, how many white Elantras are there? How many Vans shoes are there? Things like that. So I do think that there are some ways to poke holes and potentially gain some reasonable doubt. We also don't know if he has an alibi. We also don't know if there's other potential suspects that the defendant may be able to point the finger at that may have more of a motive than he has at this point, that we don't really know what his motive may have been. So there are different ways, but it's so early. So it's hard to really figure out which defense strategy they're going to go with. Happy Phantom. Why would someone innocent want to delay entering a plea for 6 months, though? If I was innocent, I would. I would absolutely want to delay and let my defense team prepare for these 6 months and not just jump into it and be unprepared and make it look even worse and make me look even more guilty. Southern Mama. If they discover another killer, not saying they will they be tried together? Will it change the preliminary hearing? Congrats. Love being a member. Thank you, Southern Mama. It will change the timeline potentially. They could be tried together potentially. We're seeing that in the Chad Daybell and Lori Vallow case, also in Idaho. It would change the timeline of a lot of things. It wouldn't necessarily change his timeline. I think it would be interesting based on what some of law enforcement has already said. There have been some discovery questions about a co-defendant or another potential suspect in this case. A lot of people are reading into that a lot. It is kind of just a standard discovery question that a lot of defendants ask in this situation. But with all the other context, how would he have done this in such a short period of time with 4 people without anybody waking up or seeing him? Did he ask if anybody else was arrested? We don't really know that yet. I don't really feel like it's been confirmed to the level that I trust it as for sure the truth. But they are asking about it. So if there is any evidence of a co-defendant, the defense is going to get their hands on that through discovery. DC Primetime, welcome to the membership crew. Mark York, wow, gifting memberships is a great idea. I got the idea from the chat and all the people that gift memberships in here. Paula Kitchen, what was the request for discovery by the defendants in that document it discussed a co-defendant? That standard lingo. I wish I would have waited for this question, Paula, but I just answered it. It is a standard discovery question, but sometimes those questions are asked because the defendant has told his legal team that we need to ask these questions. Heather, can you go over the rules of discovery? At what time do they start sharing? What are the discovery requirements for the preliminary? Does it differ from the trial? So there are different rules of evidence and rules of discovery before the preliminary hearing, but there will be discovery taking place now. The state has to turn over what they have to the defense, what they plan on using in the preliminary hearing. Discovery can be written where they ask questions back and forth. It can be document production, and it can be depositions. So we'll see. We won't necessarily read the depositions or know who they're deposing when they're deposing them. We may see some of the discovery questions or document production come through if it becomes public and it's, worth discussing and looking into. So we'll still have to wait and see as the evidence comes out and we figure out what evidence they have against him. Rebecca, thank you so much for this super sticker. One of the really important things in a preliminary hearing is how the defense cross-examines witnesses. It's not always exactly how you would cross-examine a witness in trial, especially if like DM takes the stand. The state does not have to put on all of their evidence, just enough to overcome that burden. So if they have either a shaky witness or somebody that is a victim in this case, like DM, and they don't want to put her through all of these questioning, maybe they won't call her at the preliminary hearing. They'll save her for the trial. Maybe they won't even call her at the trial. So you can make those kind of decisions as the state in a situation like this. DC Primetime, Peter, what evidence do you think they will try to keep out in the pretrial? Can we expect a lot of defense motions to suppress the state evidence? Thank you in advance. I don't know the answer to this until we hear a little bit more about the evidence. I don't think they're going to suppress any of the public data, the cell phone pinging. I don't think they're going to be able to suppress any of that. The DNA evidence on the sheath, I don't think they're going to be able to suppress that. Maybe they'll try to suppress the trash DNA match from his dad from the parents' house. I don't think that's going to work. The car, a lot of that is on the street cams, which is all public when you're driving your car on the streets. So I don't think they're going to get that. We'll see. I want to reserve ruling on this until we hear more about the evidence. Stephanie Coker, sorry if you answered this, but what is the difference between the preliminary hearing versus preliminary trial? Thank you for your insights. So that's why I like to call it a preliminary hearing and not trial. I understand people use different verbiage, but it's more confusing to call it a preliminary trial because it's not a trial. It's a preliminary hearing, and the judge makes the decision. The trial will come later. Hopefully, I was almost about to say there's only one trial. Hopefully, there's only one trial. What is the deadline to collect evidence? Alicia Johnson said. There's no real deadline. They can keep collecting evidence. There'll be a discovery cutoff at some point, but if they collect some big piece of evidence, they'll continue the trial and extend discovery so that they can produce that discovery to the defense. There's no real deadline to stop collecting evidence if evidence continues to come in. Tori, as much as we want a speedy trial, they should cross all their T's and dot all their I's so the right person is convicted. I don't want to rush trial just because we want to see the trial. Thanks, Peter. 100%. I'm with you. I agree with you. If this was your loved one, you'd want the same thing. If I was the defense lawyer on the case, I'd want the same thing as well. Mercedes McLaughlin, does the state have to share all the evidence before the preliminary hearing? They don't have to share all of the evidence before the preliminary hearing. It's an ongoing process, and they can share enough in the preliminary hearing that overcomes the burden of it's more likely than not, according to the judge, that Bryan Kohberger committed these crimes. Now, throughout the discovery process, they have to give over everything to the defense that they plan on using at trial and all exculpatory evidence that may prove the defendant's innocence. Eric M. Junker, can you ping two cell towers at the same time? Better location where the phone is? I don't know the answer to this. We have hired in the past cell phone experts. That's what we would do in this case, and they would explain how all of that works. Queen B, will he wait for the preliminary in jail or prison? Will preliminary be televised? County jail is most likely where he will wait until the preliminary hearing. I think at this point, it seems like the way that they're doing it is recordings and cameras are allowed in the courtroom, but not live stream. So we'll have to watch it after the fact, which may be kind of weird watching it at night. Maybe it'll be cool. We'll be able to do it. We're adaptable. Hopefully the home studio will actually be set up at that time. So we'll be ready to rock and roll. B Sun. Left sheath on purpose to deflect. Accidentally left a tiny amount of DNA. I've heard this theory. Would have been more if he forgot. No reason to take it inside. Extra time to remove it and replace the knife. Arrogance. I mean, it would be a really, really dumb thing that got him caught, right? Because I think that's the most important piece of evidence. And to throw him off because it was leather, because he's not USMC. I mean, I don't know. It's just, it seems so weird. It's so strange, right? It's so strange, which is why everybody wants to hear from him if he pleads guilty. Like, what happened? Why'd you do it? How'd you do it? Things like that. David Roberts, welcome to the crew. Sky Marketing. Queen B, does the defense attorney ask him if he did the crime? Not usually. I mean, every defense attorney is a little bit different. Most of the ones I know, myself included and my dad included, we don't ask them if they did it. We ask them what happened, right? And sometimes if they tell us what happened, they tell us they did it, then that's one thing that we have to deal with, right? And usually it comes down to working out some kind of a deal. If they tell us what happened and why there's a misconception or misunderstanding why it's them, that kind of begins the story and the theory of defense, poking the holes, producing other suspects potentially, and trying to prove that they did not do it or poke holes in the way that the state tries to prove that they did. Jeannie Nash, thank you for the super sticker. Harry Phantom is a new member. Kelly Guerin, from him saying that the shopping's better in Idaho, what if he's a Dasher Instacart shopper? Love your channel. I don't remember him saying this, so I'm not really sure what that means, but we do know that there was a DoorDash order at 4 a.m., and then that's right around the times that the crimes were committed. It seems like that person has been ruled to not be a suspect in the case, so I'm not positive the context behind this comment. Azam, what's up? She was with JB today. Welcome in, and thanks for the super sticker. Will there also be a grand jury, Magical Mary said? It seems like the answer to that is no. Sometimes it's hard to put a grand jury together. I think they do have the grand jury in Idaho, so it doesn't seem like that's the route they're going to go. What's her name? I'm not sold on his guilt yet. Now, if his DNA is under their nails or DNA is present in his car, then that's almost impossible to explain away. I agree. Or if their blood is in his car, or they find his DNA on their bodies and things like that, I agree with you. I think there's still a lot more evidence to be built up by the state. Now, if you look at some of the context, some of the other documents that have been filed and things that we know to be true, they still thought they would need potentially till March 1st to complete this investigation. So I think there are still documents that are going to be unsealed and things for us to continue to talk about in this case, even though we do have this delay. The discovery is happening. I think things are still going to happen between now and June. It's not going to be just total silence. Jonathan Perozois. Do they discuss if he gets coal for next Christmas or not at the preliminary hearing? You guys, you're making it difficult for me to keep a straight face. But we deal with difficult subjects on here. I understand that. And sometimes to make light of some of the situation, I think is okay. I know some people don't like it. But we're talking about this case. We're trying to talk about the legal angles of it. And I think it's okay to throw one of these in once in a while, especially with the prosecutor in this case. Ashley Harris, thanks so much for the super sticker. Do you think the judge will bar cameras from the prelim? I think it has to do a lot with how we talk about this case and how we deal with this case. In social media, as the public, I think we should be respectful. I think that we should not convict Bryan Kohberger before this all happens. I think we should presume him innocent, as is the laws of our land. I think we can keep an open mind. I think we can talk about certain things and say what ifs or maybes, I think, are okay sometimes. Asking questions about documents are okay. But I think if everybody's respectful, then the judge will potentially, at the very least, allow cameras and recordings and then play it afterwards. Maybe the judge won't let any of it come out during the hearing. And then after it's all done and she makes her decision, then they'll be able to release all that. I don't know. The judge has discretion for that. Falvo FH, thank you so much for the super sticker here. You guys brought the questions tonight. You brought the questions tonight. We are burning through them, though. This reminds me of the old Johnny Depp, Amber Heard days where there's just question after question after question. Squab Bob, is it probable he could be an accessory, a driver, if you would, to a found and willing serial killer he's studying, or that may be a defense? So this sounds like if I was writing a movie or a show, this is a pretty decent script. Now, could it be true? Sure. It seems like there's no evidence of that at this point. It's really interesting to me to think of all the DNA that we were told is on this house, the stacked DNA from all the college students coming in and out of there, and there's no other suspect. There's nobody else with a motive potentially. Really interesting to me. That's something I think the defense is really going to be able to look into. DC Primetime. Peter, what types of measures will be sought to protect this case from the appellate process? Patience, professionalism, respect, not trying to violate any of his rights, giving him his time, doing these colloquies, making sure everything's explained to him appropriately, putting a very good public defender on his case, somebody that's death penalty certified. All of those things are the types of measures that we want to take to make sure that we protect this case from appeal. Oh, gosh. All right. Hold on a second. All right. Sky Marketing. Thanks for the super sticker. Will it be better to have DM take the stand during the preliminary or the trial, or they will have enough evidence they don't need her to take the stand? It's a strategic decision by the state. If they have enough without her, then I don't think that I would put her up potentially at the preliminary hearing. I probably would put her up at trial. And Springer, yeah, 4,000 in the chat. How many likes do we have? Are we up at 4,000 likes just yet? Hit that like button if you haven't already. Thank you, Julie. CLV USMC. Do you think the multiple noise complaints and cop visits in one night and on multiple occasions could have put a target on the house for the killer? I'm not so sure that they put a target on the house for the killer. But if we're talking about reasons why DM did not call the cops, it could be because, hold on one second, sorry. It could be because of all of those instances and interactions with law enforcement that she didn't want them to come out to the house again. Maybe they were drinking. Maybe there was drugs going on. She knows the cops have been out there multiple times. He said in one of the videos with Kaylee Gonsalves on it that if I have to come back here, you're the one getting a $300 and something ticket or violation or whatever it may be, fine. And maybe that was going through her head, and that's why she didn't call until she confirmed the worst, which I think makes sense. Eric M. Junker, Goggle, anyone can buy that knife. Google, I think anyone can buy that knife for like $89.99 and up. Michael Sharp, how long will it take to process everything taken from his apartment and college office for the prosecution to analyze the results? I mean, it varies. It took him one day to turn around that DNA evidence, but it takes months sometimes to go through all this stuff. Angela Petrick, congrats on 175K, Peter. Do you think his personality can't help but take the stand? We've thought about this in other cases, and sometimes we're right, sometimes we're wrong. To me, most criminal defendants in this situation don't take the stand, but if one would, it feels like he fits the profile. So we'll see. We'll see if he does. Thank you for the super chat. Jonathan, I heard someone admitting that they sold him the murder weapon. Is this true? And that person is now going to get gagged. I don't know. Why would you admit that is kind of weird. I mean, I guess maybe it would help convict him or saying, oh yeah, I know he had that knife because I sold it to him. It could be a witness for the prosecution. But I don't know. There's no way to tell if some of this stuff is legit, until it comes through. Like if we hear it at the preliminary hearing, then at least law enforcement in the state thinks it's legit. So that gives us a little more to go on. Janet, just noticed you hit 175K. Congratulations. Yes. And it was awesome. And you guys have been a groundswell here over the last couple weeks. So now is probably a good time to mention this. So the next milestone is 200K. Really, honestly, when I started the channel, never thought we'd get to 200K. So what I might do, if we can get to 200,000 subscribers, so tell your friends, if you haven't subscribed yet, subscribe. And you're interested in that Sarah Boone suitcase murder trial that's a couple hours away from me. If we can get to 200K before that trial ends, I will drive over, sit in the courtroom, look at the jury, look at the judge, look at the lawyers, and provide content from the actual trial. Not inside the courtroom, of course, but outside the courtroom and daily at that trial if we can get to 200K by then. If not, I probably won't make the drive over there and do that. But if you guys want that and you want to have me start doing stuff like that, or if I can fit it into my schedule, hop over there for a day or two or some of these big trials, let me know. And you can show by liking the videos and subscribing. What's her name is now a member. That's awesome. Thank you, Virginia, for the super chat. Kyoe, in high-profile cases like this one, how common is it to allow cameras in the preliminary hearings? Can a judge ever keep a preliminary hearing closed so general public can attend? So as we've seen in the Lori Vallow and Chad Daybell case in Idaho, it's up to the judge. The judge can say no. And in the interest of justice, no cameras in this hearing, no cameras in this trial. And it's not even an appealable issue. So the judge can do that. I would say most of the time you err on the side of public access because the public is, these are supposed to be public proceedings and there is a public right to view this stuff, but it's not absolute and you have to weigh it against the defendant's rights. And if it's going to hurt the defendant's case or make it less likely that he gets a fair trial, then no cameras. Thank you, Virginia. And thank you, Karen Bunch. DC Primetime, Peter, time to mod some folks. No big deal. The chats are getting pretty big. So let me know in the chat if you've done that before and maybe we can hook up some new mods for the next one. Thank you, Jody. Katie Scarlett. If, like you said, DM would end up being too shaky or nervous and she never goes on the stand, could this majorly hurt the prosecution? Potentially it could, but it really depends on if they have enough evidence without that, right? That's really what it's going to come down to. And the state's going to know that. Law enforcement's going to know that. They understand it better than we do. They know a lot more about this case than we do. So if they feel like they have enough evidence, they also know this judge. They prosecute in front of this judge. So Mo, If there are not enough towers to pinpoint his phone locations, could they get the tower's phone range thrown out? Even if you are driving on that highway, you are within cell tower range. I think the judge would probably allow the evidence to come in. And she would allow, and because it is, if the evidence is credible, right, and authentic, I think she would let that evidence come in. But I think that's what she would tell the defense is you can pick apart the credibility or the weight that the jury should give that evidence with your experts. So yes, this is a cell phone tower. He has a cell phone. It pings. That's a fact. But the defense then can come up and say, but we're nowhere near each other. I'm sorry, we're not nowhere near each other. I can be nowhere near that tower and it can still ping. It's a 20-mile radius, meaning the house is 20 miles this way of the cell phone tower. I could have been 20 miles that way, 40 miles away from the house. So those types of questions, explain it to a jury, and then the jury's got to decide. Sawyer Harrison, first time catching a live. Love the flow, Peter, and love the work you do. Thank you so much, Sawyer. Appreciate that. Mo, are you okay? You look like you got some bad news. John had to reboot his computer. That's why the comments kind of went crazy there for a second. That's the bad news. Just Debbie, just found you. You're awesome. Just Debbie, thank you. Hit that subscribe button, hit that like button, hit that notification bell, and join us more often, Debbie. We'd love to have you. Best chat in the game. Awesome group of people, super nice group of people, respectful, ask good questions. We disagree. Diverse backgrounds. We're not all the same. We don't all think the same, from different places, different kind of people, but that's what makes it interesting. That's how we learn. CMC, I'm a member for 7 months and you hit 175K. CMC, the OGs like you that keep the channel growing and moving. Chastity Mason is a new member. See, 7 months from now, masterpiece. All you guys are going to be able to say the same thing. And Goldie Glocks. Janet stuttered. I went to Casey Anthony trial for 1 day. Might do Sarah Boone. Janet, maybe some of you will see me there if we can hit 200K. That'd be interesting. Stevie is a new member. Brian, Emily D didn't like the 3-part interview from the defense. It made me think it was lever chess move to keep cameras out of the courtroom as it might be violating the gag. Is that a crazy thought? I'm going to try to decipher here, Brian. You're saying they did it on purpose potentially to make sure that the court gagged it or even to violate the gag order. I don't think so. I don't think they were trying to violate the gag order on purpose. Yeah, the more I think about that interview, it wasn't great. You know, I'm going to give him the benefit of the doubt. I don't know him, so I hope he was just trying to do what he thought was right. But, you know, like I said, not something I would have done. Amanda Blackburn, love the content from the UK. You guys are awesome. I mean, it's been a busy day, right? And it's 9:30-ish my time. I'm pretty tired, but you guys are bringing the energy and keeping this fun and keeping it interesting. And that's what I really appreciate and what makes this really interesting to me. Tina Crichton, pack your lunch, Peter. 200K will happen. I'm a betting gal. I love it, Tina. I love the confidence. And I'll be ready. I'm going to make it happen. I'm going to make it happen if we get to 200K. Elaine O, has anyone questioned how his father ended up driving back to Pennsylvania with him? Did he know what was going on? I got to be honest. Common sense would tell me a 2,000+ mile trip across country. I wouldn't want my son, regardless of how old he is, doing it on his own. If he let me drive with him, even if he's 28, I would do it too. So that really, and the timing of it is exactly when Christmas break would have been. So I don't think it would have been suspicious to his dad. The reports of him cleaning the car, though, were after he drove across country with his dad, I think, which would be really weird that you'd let your dad come in the car with like blood and stuff all over. But I guess he could have been cleaning it for like DNA you couldn't have seen. I don't know. Just some stuff that runs through my head. Willie99, think it's possible the Tapa Talk posts he made was all a part of the perfect murder plan, leaving a digital footprint of mental health problems. It was around the same time his friends said he changed. Possible he just has mental health problems. It's possible those posts are fake. And it's also possible that, yes, he was laying the groundwork based on his background, based on, you know, his experience, what he was learning in class, that he was trying to set up the perfect murder, and he just screwed up by leaving the sheath. I don't know. K-Jab, prediction, 250K sometime during this case. Mark it down. K-Jab, come on now. We don't want to set unreachable goals. We want to set reachable goals. But I do like the way you think, right? Paula C., will they still unseal the search warrant in March? Yes, maybe even before. David Roberts, if found guilty, would the same prosecution team be in the trial for any new potential suspects? So I would think so. It would make sense resource-wise to not have people have to relearn the case, but it would be really weird based on what law enforcement is saying and how this case is going if new suspects popped up now. Shannon Bryant, loyal follower from JD trial, glad to finally be a member. Shannon, I'm glad you're a member too. Allie Foley was on a jury where we used cell phone data to help convict the defendant of murder. The amount of data they can get from one ping is mind-blowing. Absolutely. And it's funny, I've talked to some people, and some defense lawyers call it junk science like Bryan Kohberger's did. Prosecutors usually say it's not junk science to the jury. And that can be for DNA evidence, for cell phone tower pings, for lots of things. And that's what I said, in a CSI world, juries usually love this stuff. They love a story like this. They love to hear, oh, there was DNA evidence. Oh, they got him from his cell phone ping. Oh, he turned it off at the perfect times. That makes total sense. It goes with the story. It makes sense to the jury. The jury likes to use their common sense. They're even told to use their common sense. So that makes sense, Allie. Thanks for sharing your experience with us. Kaya, do they have to go through Daubert for the expert witnesses and preliminary hearing, or is that just for the actual trial? Kaya, I don't know. I probably could look that up, but I'm not going to look it up right now, but I think that's a good question. I'll have to look up. I don't even know if they're a Daubert state or if they're a Fry state or what the standards are, but whatever their standards for experts are, yes, their experts have to go through, no, not before the preliminary hearing usually. Usually they don't have to go through for the preliminary hearing, but I will say FBI agents and law enforcement most of the time can clear whatever bar is set for experts in that state. I've had law enforcement officers that I've done a Daubert hearing on in Florida that didn't even have the certification or take the test at the time they performed, whether it's, field sobriety exercises or whatever the testing that they thought. One was in a computer case. They had gotten certificates and done testing after they performed the duties. And the judge said, oh, that's good enough. They have it now. They were in the class at the time that they were doing it. So it's really skewed in favor of law enforcement being experts in whatever their field is. DC Primetime, Azam should be a mod, and Me Too, JS Pinellas County OG. DC Primetime, you're on the list. I'll talk to John about it. I don't even know how to set up mods, if I'm being honest. And I usually like to let people go. If people are making fun of me or ripping on me or whatever, that's usually fair game in this chat. If they're ripping on other people or starting fights for no reason, try not to have that just because it's not really fun. And we try to have fun on here. Vet Mama, thank you for your family's service. Shoot, I just unstarred another new member. Virginia's a new member. Jennifer's a new member. If I didn't say you were a new member tonight, thank you so much to all of the new members because I accidentally unstarred one of them. Adrian, what will happen if he ends up with dissociative identity disorder diagnosis? They will have to have a mental health expert explain why that would affect the case. And if this disorder makes him not understand the crime or understand what he's doing or make him understand that he is killing or hurting a person, then it could affect, even though it's not guilty by reason of insanity, it could affect the mens rea. Could he form the criminal culpability to even commit these crimes? Southern Mama, you in the courtroom, I object. Wait, let me check with my lawyer, chat crew on this. LOL, I have loved seeing this chat grow. Hit the like, y'all. Well, you're a big part of it, Southern Mama, so I appreciate it. Adrian made the plunge to membership, as well as Jadzia. I know I blew that. I apologize. K-Jab, believe like the Hawks. No, don't give me their odds. Come on. Julie, you're the best, Peter. Love this group. Congrats. Thank you so much, Julie. Was it the judge, or what is the judge ruling on at the preliminary hearing? The judge has to decide, based on the evidence presented, is it more likely than not that these crimes, the 4 murders and the burglary, were committed by Bryan Kohberger? Mo, the cell phone location evidence on the Kevin Eastman case was crazy good and conducted by Cass, the FBI, who is also on this case. Correct. And again, lay people usually love it. Dr. Anya, I have been here from the start. I knew you'd do great. Plus, go Knowles. Thank you, Doc. Appreciate it, man. It's awesome. All the OGs coming out. LMM is a new member. New Chris, one, I'm not New Chris. I'm here as an independent entity on behalf of my client, New Chris 024. How would you defend Kohberger if you were his lawyer? So we've talked about this already a couple times tonight. I think the biggest thing is it's hard to say without talking to the defendant, right? If he has a story of what happened that we felt like we could prove, you'd go with that. If we found other potential suspects that we think have more of a motive and opportunity, you go with that. Regardless of what your theory of defense is, there's a lot of holes to be poked in this evidence. Even if you believe the cell phone evidence, that doesn't mean he committed the crime. So if the eyewitness report falls apart, if the van's shoe print falls apart, if the trace DNA falls apart, you can pick those holes, pick them apart. And any one piece of evidence that we saw in the probable cause affidavit is not going to be enough. If you stack it all on top of each other and it's pretty solid, I think a jury is going to believe that and he's going to be guilty. Mary Farrell, any thoughts or info to share on possible motive being related to inspiration or influence from BTK, given the connection via his PhD professor? People are trying to find all sorts of connections and motives. To me, and I talked about this a little bit off the record with JB, and I'll just kind of share my thoughts. I got to be honest, you can call me cynical. This is pure speculation, which we don't like to do on this channel. It just seems like it would make most sense. There's kind of two options that seem like it make most sense. He did have this fascination and it was based on all of his background experience and he wanted to go do this and he did it and it was random, or he had a crush on one of the girls and it didn't go well and it turned into this. That's really the only two that I can kind of get behind or understand or think makes sense at this point. But again, there's literally no evidence for any of that. So I'd really like to see what comes out to see if there is a connection. Jesse Matthews is a new member, as is Chris D. What's up? Hair Bear. DM didn't know what had happened to her friends when she saw BK, and that's probably why she didn't see the urgency in calling the police. But she was frozen in fear, right? She said that. So why was she frozen in fear? And then if she was, why didn't she do anything else after the fact? Now, here's a plausible explanation. I see a guy walking down the stairs in all black with a mask on. I'm like, holy crap, frozen in fear. I go shut myself in my door. Now, could be a random dude that was just hanging out with the girls up there. And I was like, why are you guys having these creepy guys hang over? Why? Who wears all black and a mask at night walking down the stairs at 4 a.m.? But lots of people in and out, lots of people partying. So she was like, oh, that was kind of creepy and weird. But she goes to bed, wakes up in the morning, and realizes the worst has happened. I think that's a plausible explanation. I think there are some things defense lawyers can do with even that explanation. Like, well, maybe even it was Bryan Kohberger. Maybe he was just there hanging out with one of them. Maybe he was just a guy coming in and out of the house, since that happened all the time. There were people, guys and gals, coming in and out of the house for parties late at night, early, eating a pizza with them, whatever it may be. So there's a lot still that can happen with these witnesses. Allison Warren. Hi, is it possible BK secretly gave PA lawyer the thumbs up to talk to media to have some on his side poking holes since the gag order doesn't apply to him? Gag order could apply to him, which we kind of already have gone through, but that's absolutely possible. And that's what I'm saying. Give him the benefit of the doubt. I would probably say, I'm allowed to talk about this stuff or whatever, just to kind of clear that air. But, my dad was talking about how he doesn't think anything is basically good for the defendant to leak. I talked about how I could possibly think certain things if somebody were to talk to the media about it, if there was no gag order, maybe it could help with the public, convicting him without hearing all the evidence at trial. I don't think these interviews have been overly helpful or overly negative for Bryan Kohberger to this point. Chris Mike, Peter, if one of us were to find ourselves summoned for jury duty for a trial in which you were an attorney, would you have to disclose that we watch your channel? Yes. So they ask you, do you have any contact with any of the attorneys or people in this courtroom? You'd have to say, I watch that guy's YouTube channel. Now, I hope, but I want you to be honest. If you were asked, well, would that make you biased in this case, or would you be able to look at it and stay fair and unbiased as you weigh all the evidence? I hope you'd say, well, I know he'd be disappointed in me and everybody in this courtroom would be disappointed if I was biased or if I wasn't able to just look objectively and weigh this evidence and apply the law and make the decision based off of that, because that's literally what I learned on his channel. So yes, I could be fair and unbiased. And then it's up to the state if it's a criminal case, or the defense if it's a civil case and I'm the plaintiff's attorney. If they want to say, nah, we want to strike that person, they might be able to argue for cause, but at the very least they could do a preemptive strike because they think, maybe you'll just do whatever I say, which I hope you wouldn't. Pan Psych. Maybe I missed it, but how long do you think this case will take to go to trial? I think at least a year. Susie Dupree. With his Pennsylvania attorney talking to everyone now, does that give the defense a loophole to say he told the prosecution things Bryan told him? It does not seem like he's doing anything like that. He's not doing anything nefarious, like giving anything to the other side. Don Biederman. Tough decision to waive speedy prelim if it means local jail for the next 5 months. Thoughts? I've heard it argued that maybe he's safer in jail. I don't think out in the public he would feel very safe. Most people think he did this and maybe looking for revenge. He's probably in some kind of solitary or protective custody at this point. So I don't know. I mean, I wouldn't want to be in jail. I get you there, but Jacqueline Weaver, thanks for the super sticker. Do you know who, this is from Happy Phantom, do you know who Luke Magnotta is, and do you see any of him in this case? Do you think Bryan is studying us? I don't know who Luke Magnotta is. I was not big into watching all these trials before starting this YouTube channel. I didn't have a lot of people I talked about it with. Now I have literally thousands, like 5,000 of you in here that I talk about this stuff with. That's what makes it fun. So if it's an older case, I don't know anything about it. He absolutely could be doing this as one big case study, and that would be horribly sad and horrible of him. And he would get what's coming. He deserves what's coming if that is the case. Tori, been a member for almost 8 months. You're one of the first, one of the very early ones. So proud of the channel. Thank you, Peter, for continued grace and always answering our questions. No other channel goes as far as you do for your subscribers. I always try to answer as absolutely many questions as I can. I don't always get to every single one. Tori, this is why I do it. You guys are awesome and super appreciative and understanding when I can't get to all of them. Phoebe's a new member, and so is Carol McDonald. Kaya, if the decision is made to pull jurors from elsewhere in the state, would potential jurors be selected from a specific county with a larger population or pulled from multiple areas across the state? I've seen it done both ways. So this would depend on the procedure that they felt was the most fair and how Idaho does it, which I've never tried a case in Idaho, so I can't really say. Shannon Lord, I wonder how BK used his cloud-based forensic course that he took to mess with any of the technology evidence. Any thoughts? I did bring this up on JB's stream, cloud-based forensics. So I'm glad you said it better than I did because I couldn't remember exactly what it was called. But when we're talking about cell phone pings, we're talking about potential Wi-Fi. He may have some experience in this, much more than a lay person potentially. So if he really was trying to throw people off or do certain things, maybe that'll come out and he'll be able to do that. I think that's a good point. Thanks, Shannon. Rainey, isn't the gag order just till the end of February? Do you think it will be continued? I think the gag order is indefinite at this point on the trial. The sealed documents for the search warrant in Washington is just through February until March 1st. I don't think this case is going to go to trial anytime soon. I don't know if there's going to be an official continuance, though. YouTube user is a new member. Stacy P, welcome. And Jody Schweitzer, also a new member. Willie99, how would you go after DM if you were the defense? I wouldn't go after her, but I would ask why the delay in calling law enforcement. And depending on what her answer was, you can go in different directions. If it's, drugs, alcohol, partying, I didn't want to, or I was just so tired I passed out, then that brings into question the credibility of what she actually saw. Was it blurry? Does she have a proper recollection? Is there anything she may have forgotten? If she said, oh, I didn't really think it was that big of a deal because people were always coming in and out, then you can go the route with, well, maybe that person in all black wasn't doing anything wrong. Did you see blood all over them? There's a lot of context and a lot of things we don't know. She may have given more of a complete statement to law enforcement, and we just don't know what that is yet. So I wouldn't call it going after it, but I would test and scrutinize the credibility of what she saw and flesh out some of the other possibilities of what it could have been that she did see. Maybe it wasn't Bryan Kohberger, or maybe he wasn't doing anything nefarious when he was in there. Those types of questions, just honest, open questions, not condemning her, not blaming her, not making her the bad guy at all because she's not in this case or in this situation. Eric M. Junker, 4 girls living in the same house, kitchen light on all the time. Come on, common room, DM's room next to the kitchen entrance. BK would be in the light. I don't know. Logically, this goes together, but I think I just want to see kind of how all the testimony comes. Stacy P, been on and off as a member since the summer and not 100% of the time from moving down to Tampa from Buffalo, but I do loyally watch, which is most important. Each and every post and like them all. Love watching the fam grow. Thank you so much, Stacy P. Are you saying you moved down to Tampa? That's awesome. Tampa's awesome. Welcome home. Angela Thomas, survivors call friends to the house before 911. No one talks about this. Can't this dispute all physical evidence? That's why we need more. We really need more. We need more of a timeline. We need more evidence. We need to figure out kind of what's known and what happened during all of this time. Whew. All right. That was all the questions. Man, I'm tired after all that. That was an hour straight of questions, it felt like. John, thank you for the super sticker. So this is crazy. You guys have taken us on a wild ride. It's been fun. We're going to keep continuing to move forward, continuing to grow. 175K is insane. Let's keep pushing the 200K, and maybe we'll do some different stuff like going out to the trial. I'm down to try different stuff, provide different content, make this enjoyable for you, make this educational for you, as you guys always do for me. I appreciate you all so much for joining me tonight, joining me this morning, joining me with JB. Maybe we'll take tomorrow off. Maybe something will happen where we'll have to do another video tomorrow. And I say have to, but I enjoy it. So maybe we will do it. It was kind of fun doing it in the morning. Maybe we'll try that again. That was a first time new thing for us. At Tragos Law, if something pops off, send it to my Instagram, send it to my Twitter. Kaya, just wanted to say thank you for answering our questions. I learned so much every time I watch one of your videos. Kaya, thanks for bringing the questions. That is the content, literally. That's what makes this interesting and makes this educational. So I appreciate you all so much. Adrian, people need to remember DM was raised in the barricade until the threat is gone generation. Oh, raised in the barricade until the threat is gone generation. Happy to have found you. And Adrian, I'm happy to have found you too. Vincent Napoli is also a new member. I can't believe all the new members. That's so fun. All right. Appreciate you all so much. I'm out of here. Hit that like button, okay? I want to be at 5,000 likes by the time you all sign out of here. Hit that like button on the way out. You all are the best. Until next time, I'm out of here.